Lori Anderson versus Armani Lyman. State your name, please.
Lori Anderson.
I went back and reviewed the record, and what is clear in this case is for termination of tenancy.
And a judgment, sir. You want me to read my
How much are you claiming is owed?
$1,139.94 as of today.
Hang on,
$139.94.
All right, and that is for?
That is for July rent, which is
The amount of how much?
$330 plus late fees, which are $25 a day. So I calculated.
Can't do that.
No late fees?
All right. I can't let you assess late fees at $25 a day. Okay. First of all, I think under case law, it would be an illegal late fee. Late fees have to be reasonably calculated to the cost of collection. That's not an exact science, but they certainly cannot be what would be called liquidated damages, which those would be. Okay. So, what months does she owe for?
July. I got a calculation. July. That would be $3,300 for July.
3,300.
Yes, sir.
That's the rent.
Yes, sir.
Okay.
And then I got the water bill, the water charges.
And how much was that?
Oh, let me see. I had it all prepared, and I'm just.
How my day goes.
What'd you say, sir?
I said that's pretty much how my day goes. I have it prepared and then.
I had it all in order. Now, find it. Oh, God, hold on. Okay, thank you. Okay.
You got it? Okay.
Okay. Here's an order. Okay, court cost of $33.59. That's to get her served. Lawn care service of $35. She didn't pay. I had to pay for the lawn care service. Water bill for May of $207.29.
$207.29.
Water bill for June of $230.32. And then extrapolated water bill for July 1st through July 11th today of $84.45.
Okay.
Then two cashier's checks that I had to get done because she, I don't know if you'll approve that, but that's $20.
Okay.
Background checks of $54.29 for her uncle, Augustus Lyman.
Why'd you have to do?
Because he's occupying my house and he's a criminal.
Okay, I can't let you have that. All right, go on.
And then, well, late fees. You said I couldn't have late fees.
Well, how much are your total late fees that you're charging?
I calculated based on today of 175. So whatever the court will allow.
175 for July.
Well, to the I calculated to July to today's date.
Today's date.
Yes, sir.
Okay. So I'll allow you $50. Well, your monthly rent is $3,300.
Yes, sir.
I'll allow you $100 in late fees.
Okay.
Okay.
Thank you.
So what you need to do, and I will approve that judgment. Why don't you raise your right hand for a moment? Do you solemnly swear or affirm all the testimony that you have given and will give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And was there a lease on the premises?
Yes, sir.
But you're terminating the lease based on.
Okay. Can I read my little
Well,
spiel?
hold on. No, you can't. I just look at it. You're terminating it based upon the misrepresentations and also violations and fraud that you stated to the court previously in this case, as well as a misrepresentation you believe as to identity.
Yes, sir.
and the person's in home, and then there is rent that is due. So based upon that and the defendant's failure to appear in this case, court is going to grant a judgment for possession to the plaintiff with a, that's her? Okay. All right. She's here. What is your name? All right. Ms. Lyman, it is unacceptable to be effectively an hour and a half late to court.
I submitted something for Zoom because I can't be late for work class. So I just came straight from school.
And I got off the bench and I specifically looked because I specifically indicated to both parties that you needed to appear in person.
I didn't receive an email of a denial of Zoom either.
When you guys were here on the record, I specifically stated that both parties needed to appear in person. So whether or not you filed a Zoom request or did anything along those lines, it wouldn't have mattered because I told you to be here in person. And Miss Anderson, I'll have to stop the inquiry that I'm making now that she's here. What's your position on this case, Miss Lund?
She asked me to sign a 3-year lease after I already signed a 2-year lease, and then this is when everything kind of went downhill.
Do you want to stay there?
No, not really. I already told her if she gives me my $6,000, I've been stated that I will leave.
Is that the security deposit?
There's a cleaning fee and security deposit, but she never said that she would leave, sir.
So how much is the security deposit?
It's at least. And this is the first time I've seen her since she signed the lease on May 5th.
I don't care.
Okay. Oh. 5250.
And there's a cleaning fee, which is a non-refundable cleaning fee, I'm presuming, of how
Yes, sir.
much?
I have a video that she said that I could get my cleaning fee back.
What's the lease then?
Well, it's non-refundable, but I said if she leaves it really, really clean and, just like I had it, that I would be willing to, refund her that based on, being clean.
Okay.
Because
But the lease itself says it's a non-refundable.
Yeah, because I think by law it has to say that, so that's why it says that.
It doesn't have to.
Well, I don't know. I'm not
A lawyer.
I'm not a lawyer.
All right. So otherwise, two things. First of all, with reference to the I understand the oral representations that were made regarding the cleaning fee, but the lease would indicate that it's a non-refundable cleaning fee.
Yes, sir.
So,
Because I thought that's what I was.
and then with reference to the security deposit, that security deposit is can be used to pay rent, can be used for utilities and other things that may be outstanding. My understanding is that there are a number of water bills that still need to be paid. There is July rent that still needs to be paid. So, and I would have no way of assessing whether or not there were damages to the premises. So I don't know that that's a negotiation. But you say that you don't want to be there.
Well, yeah, because she has neighbors watching me, and it's very uncomfortable coming home, and there's people watching me.
All right, Ms. Lyman, let me ask you this. What do you want me to do on this case?
Really, I just want everything to be over. It's just the random people watching me, the false police reports.
So what do you want to do?
Say I can move out in August.
When?
least the 1st or the 6th.
Okay. And what about July rent
I was just put the rent as well.
with the court? And that's $3,300. There's approximately, I have about $500, give or take, for the water bills.
I just want water bills are supposed to come every 3 months.
I sent
I
a,
received one almost like every, and from the first water bill, I was only there for 27 days.
can I make a comment, sir?
Sure.
I sent an Excel spreadsheet to the court and to the defendant that shows the water bill history for the last 3 quarters. I mean, 4 consecutive quarters, and it calculates a water bill based on my usage versus Mrs. Armani and her family's usage. And there's a significant difference. And I presented that to the court as well, that showed that she's using 3 times the amount of water with her family than I ever used. So, well, the police report indicated that there was a,
Just because it's people over there don't mean people.
There's really no reason for me to be here with you two, is there? Because you're just going to talk over each other. And when you talk over each other, I'll be honest with you, I'm not even listening.
can I make a statement, sir?
You have. Go ahead. What is the statement?
This is the first time I've seen her since May 5th because an older woman who says she's Armani, she's at least 40, has been telling me she's Armani, but I think it's her mother, Joanna Lyman, and I've never been able to speak with her or see her. So I can't even talk to my tenant. I would have liked to have tried to work something out, but I'm not able to ever talk to her.
Yes.
That's a lie. She's seen me on multiple occasions. She doesn't even know anybody else who's ever met my mother. She's only met with me every single time. The witness statement about mail, I've never met that man. The mail's always been inside the mailbox. I've never met any of the neighbors because I don't even go confront people. I just go on by my day. So of course, none of them ever seen me, but her.
And the fraud about the address that she said she lived at. In fact, she was living at a place on Maplewood that she was actually being evicted from. And she told me she was living at Mr. Diop's house that's on her driver's license that he's lived in for 3.5 years. So that was the fraud and misrepresentation of the truth. She was actually being evicted when she moved into my house. And I didn't know this.
Well, there's a difference. Does she represent that she wasn't being evicted?
Well, she said that she was living at Mr. Diop's house, who's been there for since 2021 and says he's never rented to her. So that's fraud.
What do you people want me to do? You guys just want to argue with each other. Quite frankly, I don't have the time today to hear all this because this is just a mess. You guys can't get past your personal animosity toward each other to even look at this whole thing rational.
Judge, the phone number on her application was disconnected. I've not ever been able to call her and talk to her. For 2.5 months, it's been another lady talking to me on the phone and in person. I've never been able to talk to my tenant. We could have worked this out if she was actually talking.
Not the way you two are acting right now, because you're both acting like juveniles toward each other. You guys can't talk to each other.
I want to talk to her, not her mother. Sir, respectfully.
Yeah.
She asked for a past address. 9090 is a past address. I never told her that I lived in from the lease.
Why do I care?
The application has 9090 on it.
You're just going to keep showing it to me, so I got to try.
I just want honesty.
She's only been talking to me.
You guys can't even resolve this, can you?
I don't even have her number, sir. I don't have a number. You don't talk to me, sir. You don't talk to me. I've never.
You know what? Both of you go sit down. These other people, I'm not going to have them waiting through your mess. Go sit down. I'm going to pass this case. No, I'm not even going to pass it because I don't want you back up here right now. I'm going to set this thing for a final settlement conference before trial. I'm going to set it for this Tuesday. Oh, joy. And then I'm inviting her back. So, go ahead. What time on? It's 9:00 this Tuesday, the 15th. Final settlement conference, July 15th, 2025, 9 a.m. That's in person. You need to be here. I will be waiting in courtroom A to hear your case and other cases with bells on.
The rent, since the mortgage is due, can
9 a.m. on the 15th. I am not making a decision today. You are to put the $3,300 in the court escrow. Thank you.
Thank you, sir.
She just said something. Anybody comes up and gives me a problem, you're going to be. I see. What do you say?
I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing
So-
since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes,
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it. But she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was.
Not by me, Your Honor.
Yes. Okay, I see that. But that was not the original.
I have not seen that.
stamps on here. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
And may I show this to you?
No,
This,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to,
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
If I may, Your Honor, briefly, just briefly. This is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's of course your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started, if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of you.
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to...
Are you almost done?
Yes, to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that, if the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond, and now you want to go back, and you guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases, so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not gonna yell when you're in here. You're not gonna whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
This courtroom exchange quickly turns chaotic as a landlord and tenant clash over unpaid rent, fees, and alleged misrepresentation, with the judge stepping in to restore order and focus on the law. The landlord attempts to stack charges, including excessive late fees and questionable expenses, but the judge immediately shuts down anything that doesn't meet legal standards, making it clear that penalties must be reasonable, not punitive. When the tenant finally appears late, tensions rise further, with both sides talking over each other and failing to present a clear, structured case. Frustrated by the lack of preparation and constant interruptions, the judge refuses to rush a decision, instead ordering rent to be placed into escrow and scheduling a follow-up hearing. In the end, the key takeaway is clear: in court, emotional arguments and confusion only weaken your position. What truly matters is clarity, proper procedure, and solid legal footing.